We're back, and what a delight to be able to say on any given occasion that the chairman of the board of the Institute for the American Future and one of the emerging preeminent pundits of our time, that would be Rod Martin, is in the house. He is, of course, a serial entrepreneur and a man whose writings, as well as his other public musings, now at rodmartin.org, where you can find the Rod Martin Report, which I encourage you to subscribe to. It's a fabulous resource. And Rod, I haven't had a chance to see what you will say in writing about the new decision by the Supreme Court on birthright citizenship. But I get to have you say it to us before you put pen to paper on the subject, or mouse to pad, whatever you do to make this magic work. But thank you for joining us, as always, my friend. It's good to have you back. And as we speak, we've just had the ruling handed down, so I wanted to get your immediate reaction, sir.
Yeah, the ruling came down about 5 minutes ago. It is certainly disappointing, but it's important to keep perspective. It doesn't put us in any different position than we were 10 minutes ago. It just is a bad decision, and it really is a bad decision. I was holding out hope based on the Mississippi ruling and the IEPA tariffs ruling that they were just being pedantically textualist, which is actually, if you're going to have a fault, a pretty good one to have. We want the Supreme Court to be extremely textualist. Well, that theory gets a little bit blown out of the water by this birthright citizenship case. There is simply nothing in the 14th Amendment that in any way pertains to illegal aliens who just happen to show up and have a baby. It's just not there. And the proof of that is multiple in nature, but let's just start with a couple. The Wong Kim Ark case, which is cited in support of birthright citizenship, involved the child of two legal residents of the United States. It clearly was not dispositive on the question of illegal aliens. Second, the children of foreigners here in some limited capacity, such as the children of diplomats or the children of soldiers training at Fort Bliss, or anything of that nature, are explicitly exempted under statute. If the Supreme Court wishes to actually carry through on this honestly kind of pathetic ruling, they would have to make all the children of diplomats born in the United States U.S. citizens by right. It's absurd. It's not the law. It's not in the 14th Amendment. And I'm very disappointed in Barrett and Roberts, who are the two supposedly conservative justices who came down on the wrong side of this, along with the three communists. So, it's just a really disappointing decision, but in a week of mostly really great decisions.
Well, I do want to talk about a couple of others, Rod. Amy Coney Barrett, of course, was the author of another, I think, deplorable decision on the whole issue of election day and mail-in ballots. Talk us through that one, if you would, please.
Well, the Mississippi case is interesting because what they said, and by the way, make no mistake, I'm with the dissent. I totally agree with the
For the record.
But I didn't have a big problem with that ruling because what they were doing there actually was textualist. They were looking at the statute. The statute said when the votes had to be cast. The statute doesn't say when they had to be counted. And there is a practical problem there that our side is kind of ignoring, that sometimes these things actually do take a while. And we saw that in Florida in 2000. Even if Al Gore hadn't done all the junk that he did, it still would have taken longer than just election day. So the statute in question is a little vague on a point that honestly didn't even exist until the creation of this insane mail-in ballot scheme. And the real answer there is to just tighten the law. So Barrett's ruling is actually very clear. Congress has an absolute right to fix this. It's just the current state of the law isn't this in their view. And I disagree with their view. I think it's very clear what election day is. Maybe Amy Coney Barrett doesn't, but nevertheless, that was not as bad a decision. On the other hand, as you know, we just had two off the charts amazing decisions, both 6-3, one to uphold the bans on transgender athletes in girls' sports in Idaho and West Virginia, and it is a huge win because look, transgender sports is not about LGBTQ. Even if you're for the LGBTQ agenda, you should be against this because this is just fundamental fairness. We don't let NFL teams play peewee teams. We don't let heavyweight boxers fight featherweight boxers. There's a reason. It becomes unsporting. They aren't actually competing on skill in those situations. They're competing on strength. Well, we don't need that. That's ridiculous. And it just eviscerates the future of girls who want to compete in sports, which is a terrible, terrible thing. So the Supreme Court ruled correctly on that. The bigger one, the big kahuna, the one that matters this week is the overturn of Humphrey's Executor. The Slaughter case is fantastic. That is a 91-year-old case being overturned, Humphrey's Executor, that prohibits the president from firing federal employees anytime Congress says they don't want them to. And that is a step toward a parliamentary system on a certain level. But what it really did is it created the deep state as we know it. So
But I have to ask you to pause. We have a break that I have to take, but I want to come back to this because I think this is central to where we are as a nation and where we go from here.
yes,
Is whether that deep state is able to operate with impunity, as we're being told by the left. It's just somehow sacred writ that those independent agencies, despite the fact they don't appear in the Constitution, are integral.
the
We'll talk
Slaughter
about
case
that.
says no.
We'll talk about that momentarily. Here we go. We're back, and so is Rod Martin, the author and just grand poobah of the Rod Martin Reports. It's a tremendous resource, which I strongly commend to you. You can find it at rodmartin.org. And Rod, we're going to come to one of your very brilliant pieces in a moment, but just finish up your thoughts on this idea of the deep state somehow being mandated, despite it appearing nowhere in the Constitution, and the significant infringement on the second article powers of the president, no?
Look, you have two completely diametrically opposed views of how humans should be governed. You know, the one is the constitutional system that the founding fathers gave us, where you have elections at a regular interval. And if the people want to peacefully overthrow their government, they can all the time. I mean, just over and over and over. The other view is technocracy, which is just a thin veneer on aristocracy, because the idea from Woodrow Wilson and FDR and the rest has always been that the American people are too stupid to rule themselves. We need experts to do that for us. And so they made the federal bureaucracy unfirable, unaccountable. They empowered it with legislative, executive, and judicial powers, and it's run that way for decades. So if you wonder why we'll have an election and nothing seems to change, that's why. There's one president, there are about 5,000 political appointees, and there were, before Trump got started, 2.8 million federal civilian employees who are just doing whatever the heck they want without any accountability or ability to be fired by the president. That
So, so
just
this extends well beyond the independent agencies issue. This is
yes.
really at the heart of the bureaucracy itself.
Well, they chipped away at the judicial power of the independent agencies in Chevron in a fundamental way. The Chevron case was just an abomination because it prevented, in most cases, you from ever appealing an administrative decision to an Article 3 court. That's gone, but it took 40 years. Now we have the president able to fire people in these agencies. Okay, Article 2, Section 1 is clear. The executive power shall be vested in a president of the United States, not in whoever Congress decides to hand it to. And that establishes an imbalance in the separation of powers anyway. Only Congress gets to legislate, only the president gets to execute, and they don't always have to agree on what that looks like. That's the system the founders gave us. And it should mean that when we have an election, and you want change, a president should be able to come in and fire your postmaster and fire whoever at the Bureau of Labor Statistics is doing a bad job, or fire Federal Trade Commission members. And of course, the one flaw in that, the one footnote, is they also came down on the same day, yesterday, with the Cook ruling. But I'm not overly concerned about the Cook ruling. They said that he can't fire, or he can't remove Lisa Cook from the Federal Reserve Board. And they gave a bunch of squishy gibberish, honestly, about the longevity of the Federal Reserve and its unique place. And okay, whatever. And it does disturb me that Roberts and Barrett were part of that too. But they specifically said that the ruling was only valid while litigation is pending. So my guess is when this case finally reaches the Supreme Court on the merits, they're going to rule consistently with Slaughter, and this is going to be a huge, huge win.
So, Rod, I guess what you're saying that is of surpassing importance is that an arrangement, notwithstanding all of the other arrangements that the founders went to such great lengths to elaborate, namely checks and balances, that this sort of empowering of the technocrats, as you put it, or the federal bureaucracy, or the deep state, or the permanent state, or whatever you want to describe it as, for which there were really no checks or balances. I mean, I guess the Congress theoretically could undo what it had previously done, but that didn't seem to happen very often.
They couldn't get rid of individual people.
Right.
So they're there forever, and they're just going to keep doing what they were doing. That's what we saw at USAID.
Tony Fauci comes to mind as an example of this. But Rod, isn't this really restoring the Constitution? And what were those founders' ideas about making sure that there was no sort of dominant entity in that carefully constructed arrangement?
Yes, that's the entire point. And I see otherwise sensible conservatives online telling us that, this is just undermining Congress's authority. No, you're calling for the Articles of Confederation. The founding fathers did away with that. They created co-equal branches, and that means that the president has power. And by the way, the decision says this explicitly. The president is not all powerful, not even close. There are all kinds of restrictions on his power, but he has all of the executive power. And that is the law. And there's a line in the Slaughter decision that says, whatever may be left of Humphrey's executor is hereby overturned. So this is a huge, huge win for our federal system.
Yeah. And Rod, just going back to the voting issue for a moment, because I mean, this is so fundamental to our federal system, well, our system writ large. Are you troubled about, in particular, the idea that election days are sort of open-ended and could be even more open-ended under this ruling? And should that be a subject of, well, you suggested legislative attention.
Oh, it's just dumber than a box of rocks. And the dissent was brilliant on this, as you would expect from Sam Alito. And this is a no-brainer. Election day is a day, and everybody, I mean, it's just dumb. But Barrett's decision makes clear Congress can fix this. And if they pass the Save America Act, this gets fixed. Full stop.
Let's make sure that happens. Rod Martin, we have to leave it at that for the moment. God bless you and the great work you do at rodmartin.org. I know you'll keep it up, and we'll talk to you again next week. I'll talk to the rest of you, I hope, next time. Until then, go forth and multiply.